Welcome to this short 2TG Employment Group webinar on current developments in employment law. I'm Niazi Fetto, and for the next few minutes, I'm going to be taking a look at adequacy of reasons appeals in the light of a recent flurry of cases in the EAT and Court of Appeal. We employment lawyers can be cautious, cagey about reasons appeals. We often think, with some justification, that they're not welcomed by appellate judges and that they're difficult to win. But I'm not sure that that reputation is as well deserved today as it used to be. A major reason for that seems to be the crisis in the tribunals system and the impact it's having on the quality of judgments. There is and has for many years now been an enormous backlog of tribunal cases causing very long delays, combined with a shortage of judges. And so two of the great enemies of justice, haste and delay, are running amok. Decisions and judgments are delayed because there's too much to do, which in turn means that judges and tribunals are preparing them in haste. Thus, in one of the recent cases I will mention, Phipps, Lord Justice Bean wondered out loud whether the judge's reasons in that case might have been affected by the difficulty any judge has in giving reasons for a decision several months after the hearing. And he went on to describe the delays since that decision as lamentable. On this next slide, you see a list of recent significant adequacy of reasons appeal decisions. It isn't comprehensive, but I've tried to seek out the most significant reasons appeals of the last 4 months or so. 5 are EAT decisions, 1 a Court of Appeal decision. The list isn't remarkable only for the quantity of recent decisions, but also for the fact that in every single one of these cases, the reasons appeal succeeded. What's going on? Is it the impact of the pressures on the system, as I described a moment ago? Could it be due to changes in the law and the principles being applied? Well, no to the second question, at least to this extent, in that Meek remains the touchstone. The seminal judgment of Lord Justice Bingham in Meek and his dictum, which you see on the slide. So it isn't enough to show, and hasn't for many years been, that the tribunal's judgment is not a work of high-quality draftsmanship or refined expression. The judgment does have to outline the story giving rise to the complaint. It has to summarize the basic factual conclusions and give reasons for those conclusions. And the parties are entitled to know why from the judgment they've won or lost. Further, the facts and reasoning should be sufficiently set out for the EAT to identify whether a question of law and an error of law arises. So we're still looking, when we're looking at reasons and their adequacy, at whether a judgment is Meek compliant or not. Now, alongside Meek, for many years, but long after it was decided, has been the tribunal rule now enshrined in Rule 62 of the 2013 rules, requiring tribunals to give reasons for their decisions. And there's little doubt that the requirements in Rule 62 for judgments in Rule 62.5 come across as much more stringent than the Meek criteria, or at least significantly more stringent. The tribunal has to identify the issues that it has determined and state the findings of fact made in relation to those issues. It must identify the relevant law and state how the law has been applied to the findings to decide the issues. It needs to specify also how any financial award has been calculated, and it is mandatory, although softened somewhat by the Court of Appeal in several decisions, 2 of which appear on the slide. In the Balfour-Beatty and Wilcox decision, Lord Justice Dyson said of the predecessor provision to Rule 62, the rule is surely intended to be a guide and not a straitjacket. And in the Simpson and Cantor Fitzgerald case, Lord Justice Bean said of Rule 62.5 that the real question was whether the error is material, so whether it results in a substantive error in the decision itself or the reasons leading to it. In Wilcox, the tribunal had failed to recite the law in breach of Rule 62.5, but had applied the law, so the non-compliance was not material. Nevertheless, despite that softening of Rule 62.5 by the Court of Appeal, I do wonder whether its presence and its greater stringency than the Meek criteria has had a gradual impact on the mindset of appeal judges towards reasons of appeals as the generations have turned over. The authors of Tolley's Employment Law Handbook seem to agree that there is a tightening of standards by the Employment Appeal Tribunal, commenting that the EAT is less tolerant than it used to be towards inadequately expressed reasons. They mention discrimination as a particular example of this, and that's borne out by my reading of the cases. A couple of hotspots within the area of discrimination are the burden of proof provisions. So, for example, in Meshram, one of the cases listed on the third slide, which was a victimisation appeal decided in September, the EAT held that the decision had not been Meek compliant because the tribunal had made no clear or specific finding as to whether the burden shifted in relation to a particular detrimental conduct by the employer, or if not, why not, or as to the positive explanation given by the employer for that conduct. In Kareem, also listed earlier, which was a race discrimination appeal decided in July, the tribunal had failed on one issue, specifically to find whether the burden had shifted, or if it had, whether it had been discharged. Unconscious discrimination is another hotspot. In Kareem, in the context of appropriate inferences from statistics, the EAT held, citing Baal, that the tribunal needed to take special care to explain how it's reached its conclusions if it finds unconscious discrimination. It had failed to do so, including not engaging with the non-discriminatory explanation that the respondent had given. So are reasons appeals worth another look? I think they are. And there's a multitude of ways to approach a reasons appeal. But here are some of the arguments and features that have been effective in the past and which appear within the appeals decided over the last few months. Firstly, if you can show the adverse consequences that the defects in reasoning have had on the integrity, safety, or fairness of the decision. In Kareem, for example, one effect of the inadequacy of reasoning was that leading counsel for the parties found themselves unable to agree completely on which allegations of discrimination had been upheld and which had not. Secondly, can you point to a lack of coherence or consistency in the reasons? In Meshram, for example, the tribunal had found against a witness's evidence on a major issue in the case, but given no reasons for accepting his evidence on another. Do the reasons fail to approach or analyse the issues in a structured way? Keeley, for example, was a whistleblowing claim in which the tribunal had failed to follow the logical sequence of application of the statutory provisions dealing with protected disclosures, and that led to its reasons being fatally afflicted by contradictions and non sequiturs. Can you show that the reasons fail to deal with important arguments, submissions, or evidence? In Kareem, as previously noted, the tribunal had made no mention of positive explanations put forward by the respondent for its relevant conduct. Do the reasons need to be scrutinised very closely, even creatively, for the basis of the decision to be identified? In Hampson, for example, the tribunal had rehearsed the evidence in detail, but had failed to make sufficient findings of fact. And so the only way that judgment could be understood was by the exercise of a good dose of creativity. It helps to have bedfellow grounds. Inadequate reasons is a standalone ground, but tends to be more effective when put together with others, as was the case in all of the recent appeals I've listed on the third slide. And finally, are the merits of the appeal smack in the face obvious? In Phipps, the question was, is it in the interest of justice to reconsider a strikeout where the affected party innocently had no knowledge of the decision or the warnings that preceded it? The question needs only to be asked, to be answered, and the reasons appeal was upheld. Having said so much about ways to win a reasons appeal, I should say a brief word about how to defend one. The arguments tend to be very similar across the cases. Firstly, it's wrong to be fussy and pernickety about tribunal reasons, to use Lord Justice Mummery's terminology in the Fuller case on the slide. And of course, that's how Lord Justice Bingham began his celebrated dictum in Meek. Secondly, it must always be borne in mind that the EAT has a limited jurisdiction, dealing with errors of law only, and it may not exceed that jurisdiction purely because it's unhappy with the findings of fact the tribunal has made at first instance, using adequacy of reasons as a pretext. Thirdly, as is well known, the tribunal is not required to do a comprehensive job of rehearsing or addressing every item of evidence, argument, or submission put before it. It should not be held to too high a standard. And those arguments will succeed in an appropriate case. A very recent example on the slide is McQueen and the General Optical Council. In that case, the EAT held that the tribunal had not erred in law, despite the decision being, and I quote, difficult to understand and interpret, curiously structured and drafted in an unorthodox manner, with features which were not conducive to clarity of thought, expression, and reasoning. And despite all those things, the reasons could be sufficiently discerned for the case to be the right side of the line. Just. So whether you have a winnable reasons appeal, or whether you can defend the reasons for a particular decision in your favour, will be a judgment that needs to be made very carefully on the specifics of the case in question. That concludes my brief look at reasons appeals in the light of recent case law. Thank you for watching. Please do subscribe to and follow the 2TG social media channels and look out for further videos from the 2TG Employment Group in due course.